Good day, ladies and gentlemen. This is Don Green in Las Vegas, and we have a special broadcast today and a special report from Rigel Studios. Today's broadcast is based on a Supreme Court decision which came out yesterday, June 18, 2026, some 36 hours ago. And this broadcast today is to explain the decision of the United States Supreme Court, which was a unanimous decision, and we'll break that down for you in a few minutes. But I want to caveat all of this by saying that the United States Supreme Court did not render all aspects of marijuana possession or use as unconstitutional. There are some serious limitations, and we'll discuss those now. May we have the first slide, please? Yesterday, June 18, 2026, the United States Supreme Court, in a unanimous decision, that means all 9 members of the United States Supreme Court, issued a decision in United States versus Hanani. And if we could have the next slide, please. Now, let's get a little bit of background to this. Hanani was prosecuted under a provision of the federal statutes called 18 United States Code Section 922 G3, which prohibits the use or possession of marijuana in connection with a firearm. And Hanani admitted that he had used marijuana a couple of times a week. When the feds found out about it and he was subsequently arrested, he was prosecuted in federal court in Texas. And it went to the Texas Court of Appeals of the Fifth Circuit, which sits in Baton Rouge, Louisiana. And the case was taken on what's known as an appeal by the government rather than certiorari. The difference is this. When the government appeals, the United States Supreme Court must hear the decision. If it was known as certiorari, that is discretionary relief, it only requires 4 judges of the Supreme Court to decide that they're going to hear the case. But they decided because this is an automatic appeal. Now, the majority opinion was authored by Justice Gorsuch. Now, remember, he was appointed by President Trump in his first administration. Gorsuch had come from the 10th Circuit based in Denver. And his majority opinion synthesized goes to that the government has to show individualized proof. That is, that the individual himself was using illegally and maybe in possession of a firearm. Maybe he was driving under the influence of the controlled substance marijuana. Maybe the metabolites were so high in him and he may have been in possession of a firearm. This statute still is in effect. What the court was looking for is that the government cannot just say, because you are a user of marijuana, even if it's for recreational purposes, even if it's for medicinal purposes, the fact that you use it cannot be used to create what is essentially a lifetime ban or an extremely difficult process to get your gun rights back if you are convicted under this federal statute, which would require a pardon from the president if you were convicted. Maybe go to the next slide, please. Now, the Justice Gorsuch started out by saying that Hanani had used marijuana, admittedly, a couple of times a week. But he also ruled with other members of the Supreme Court, and that's with Justice Roberts, Thomas, Sotomayor, Kavanaugh, Barrett, and Jackson, that the Second Amendment protects the rights of all, unless otherwise you're prohibited. For example, you're a felon. You are underage. You are mentally incapacitated. But the government's argument in Texas and at the Fifth Circuit Court of Appeals in Louisiana was that just because you use marijuana, whether it's for medicinal purposes, whether it's for recreational purposes, the government claimed an absolute bar against marijuana use. Okay, may we go to a live shot. Now, here's the majority opinion. It was issued by Justice Gorsuch. We could have that slide, please. Justice Gorsuch wrote the opinion, joined by Chief Justice Roberts, Justice Thomas, Justice Sotomayor, Justice Kavanaugh, Justice Barrett, and Justice Jackson. Concurring was Justice Thomas and Justice Jackson. Now, Justice Alito wrote a separately concurring opinion in which Justice Kagan approved. So that's all 9 members of the Supreme Court. Maybe go to a live shot, please. The significance of this is that you've got 9 people from various diverse backgrounds, whether they're conservative, whether they're liberal, where they were appointed by President Obama, where they were appointed by whatever president, George Bush, it doesn't matter. They all sat down in their conference and they agreed that this law is wrong as applied. Again, everyone has to understand and step back just a moment. This does not prevent all prosecutions for marijuana use. For example, if you're high on marijuana and you get into a drunk driving accident or you hurt somebody, you're not going to be protected if you had your firearm on you, and your firearm could be taken away. Why? Because the statute shows that you were intoxicated or otherwise impaired. And we have a state law in Nevada, it's 0.08 by weight of alcohol, which would bar you from claiming that you were not under the influence, and then you're trying to say, well, I had my gun on me, but no, Nevada still has that law. So I can see some legislation coming up, and whether or not when someone is tested, because right now, the marijuana testing in your blood or your urine comes out to like just a few nanograms per milliliter in your blood or your urine. A nanogram is a billionth of a gram. That's how accurate this testing is. So when there's a prosecution for driving under the influence of marijuana, you might lose your CCW for 5 years. But under the previous statute, that was a lifetime ban unless you could apply through this very technical and arduous and very difficult process through the Bureau of Alcohol, Tobacco, and Firearms to say, I am no longer an addict, I don't use medical marijuana. And what I've done with my clients is they've come to me and they said, Mr. Green, I want to have my firearm, but I'm a marijuana user. At that time, I was telling them that we'll send a certified letter to the Nevada Department of Public Health saying that Mr. X is no longer using medical marijuana. And here is a letter from his doctor. And I also have my clients do a series of toxicology tests, including a hair follicle test, which could detect the THC in the hair follicle up to about 180 days. Sometimes it's longer, sometimes it's less. May we have the next slide, please? So, what doesn't this protect? Addicts are still banned from owning firearms. And if you look at the form 4473, and the questions which ask you, are you now or ever have been like an addict or addicted to drugs? And then it says, that even though you're using marijuana, whether it's medicinal or medical use or personal use under state law, that's got to change. Addicts are still banned from owning firearms. Next, whether you are presently intoxicated, and this was discussed in about the last 4 or 5 paragraphs of the decision by Justice Gorsuch, which was again agreed upon by Justice Roberts, Justice Thomas, Justice Sotomayor, Justice Kavanaugh, Justice Barrett, and Justice Jackson. So if you're presently intoxicated under the influence, you're not going to buy a gun because the dealer's not going to sell it to you. Or if you're at the firing range and you're toking up, that you're not going to be protected. You're going to be protected only for the occasional use or the medicinal use. And if it's medicinal use, they have to show probably that you're under the influence and there are other factors such as you are weaving on the road, becoming what's known as a danger to the community. And that presents the next area, and that's dangerous to yourself. You're intoxicated, you're high on marijuana, even if it's medical use, you're getting into a fight with your wife after you've toked up a little bit and you grab the firearm, you're not going to be protected. But the occasional user, such as Hanani, who never denied that he was using marijuana, you're going to be protected even if they say, well, you're an occasional user. Now, how are they going to find out about that? They're going to find out about that when the police go to your house, let's say on a battery domestic violence call, or they go to your house on a burglary, and you're reporting the burglary, and the officers see that there's a marijuana joint or a blunt inside the ashtray, and they ask you if you have any firearms, and then they immediately arrest you. No, there must be a nexus. That is, there must be a relationship between the use of the marijuana and the use of the firearm or the carrying of the firearm. Now, if the firearm is sitting right next to the marijuana, you're going to have a problem. But if the firearm is locked in the safe, it's in the back bedroom, the kids can't get to it, the door's locked, the safe is locked, the closet, it's got a bolt on it so the kids can't get it, or there's no children, you're going to be protected. Or perhaps you're in a vehicle. Suppose you just left the marijuana dispensary. You turn right and then somebody smacks you from behind. And the officer sees that you've got the marijuana plastic bag that you just bought some marijuana, and you've got your CCW, you've got your weapon on you. They must show that there is a nexus. If you weren't at fault at that accident, you're going to be okay. But if you pulled out into the street and you hit somebody without looking left or right and you caused the accident, there's going to be a problem. So I'm going to see, I believe, and in my 43 years of experience, I believe there's going to be some legislation both in Congress, because Congress could override this decision. Will it do it? I don't think so. Even though the Republicans control the House and the Republicans currently control the Senate, I think that their constituents, and looking at this solid decision. Now, a couple of times this year, the United States Supreme Court has issued unanimous opinions. The last unanimous opinion was actually authored by Justice Jackson, but it had nothing to do with the medical marijuana or anything to deal with firearms. These are some administrative procedures, some different aspects of federal law, Social Security, things like that. But for our representative viewers and our listeners, you must be very careful not to go out and just go ahead and start getting drunk or saying, oh, I can go have marijuana, because I'm going to bet you $1 to a donut that when you go to the gun store or you go to a gun show and you go up to that dealer and your eyes are bloodshot red and you smell like you just smoked marijuana, they are not going to sell you that firearm, and there's not a thing you can do, because remember, if you're presently intoxicated, they can't sell you a gun and they can't sell you a firearm if they believe that you're under the influence of marijuana. Now, if you want to come back the next day, then that's a different story. So for now, everyone's got to understand that the rather significant decision, the United States versus Hanani, is a solid decision. And will Congress override this? I doubt it, but it's possible. Can they get the majority to override this by the Supreme Court by congressional action? I doubt it. Has the Congress ever overridden the decisions of the Supreme Court? Yes, by congressional action, which was legal and lawful. If anyone has any questions, you're welcome to call my office at 702-409-8239. I hope that this special broadcast has been informative. You're welcome to call me, and please read the decision with care. Don't read the head notes, and don't listen to the mainstream media about what it means, because it's a very narrow decision. And that's exactly what Justice Gorsuch said, probably right at the end of his decision and the beginning of the decision, which was joined by Justice Roberts and Justice Thomas, the leading proponents of the Second Amendment on the current United States Supreme Court, along with Justice Alito, who filed a separately concurring opinion with an Obama appointee, Justice Alana Kagan. For that, thank you very much. This is Don Green signing off from Rigel Studios. Thank you again, and good afternoon.